The legal battles between President Cyril Ramaphosa and Public Protector Busisiwe Mkhwebane are heating up. They are at odds over the disciplining of Pravin Gordhan for approving a full pension payout for then SARS Deputy Commissioner Ivan Pillay. At the same time, Ramaphosa is questioning the Public Protector's report on a Busasa donation to his CR17 campaign. Well, Nicole Fritz is the Executive Director of Freedom Under Law, and she joins me now. Nicole, good evening. Thank you.
Good evening.
Very much for your time. Now, Advocate Mpofu says the President and Minister Pravin Gordhan are holding the country to ransom. Your thoughts?
I don't think that that's true in the least. I think what the President is asking for is an interdict. He is suggesting that he should only be required to take disciplinary action against Minister Gordhan should the review that he is seeking be finalized and the courts hold that the Public Protector's report is sound and valid. The fact is, if the President were to impose remedial action right now, before the courts have heard such a review, the harm suffered by Minister Gordhan is potentially irreparable, whereas the Public Protector suffers no harm in waiting for the finalization of the court hearing the review and making a determination. And so there is no holding of the country to ransom to ask that we await a final court determination as to the soundness of the Public Protector's report.
Well, I mean, a further point Advocate Mpofu is making is that if the Public Protector says this is remedial action, that's what you do. Because to try and argue and bring in other things, some of which we'll get to just now, is basically, you're doing what should not be done. Because this democracy, as it has been structured with all the institutions that are supposed to hold it, says if the Public Protector says this is what you actually do.
There's nothing unlawful or improper in waiting on a final court determination. And so if one refers back to the recent Constitutional Court decision regarding the Public Protector's report on the Absa Reserve Bank matter, where we had an overwhelming majority holding that she had acted in bad faith and dishonestly and imposing a personal costs order, but a minority of Justice Mkhwebane and Justice Goliath holding differently. A lot has been placed on that sort of minority dissent. But even Justice Mkhwebane, in his minority dissent, says, in respect to the Absa matter, he says that the remedial action proposed by the Public Protector is essentially so ludicrous that the Reserve Bank, with all its resources, with all its legal teams, would have known the remedial action to have been ludicrous and preposterous and would not have need to have worried, because it would have been easily settled, knowing that it would be overturned on review. Now, that reasoning can only have any merit if there is an assumption that the courts get to overturn the remedial action before it is imposed. If it's imposed and then a court determines that in fact the remedial action proposed is unsound, unlawful, beyond the scope of the Public Protector's powers, there's no going back and overturning the remedial action that's already been imposed. So there is nothing, absolutely nothing, improper in asking to await the court's final determination as to the soundness of the remedial action that has been proposed by the Public Protector.
So you're saying that the prospects of success of a review or an appeal should be taken into consideration when something like this is being looked at by a court?
Well, I think I'm saying two things. I'm saying that an application has been lodged, a review application, that the courts must be given an opportunity to make a proper determination as to whether the remedial action is sound. But in these specific circumstances, we have any number of court cases which have found that the Public Protector doesn't fully understand the scope of her powers, that the remedial action that she is proposing is not sound, is unlawful. So in the Reserve Bank ABSA matter, she proposes that the Constitution be changed. I mean, no person in this country, not the President, can effect a change to the Constitution. That's not how our constitutional democracy works. In respect of the rogue unit matter, she proposes that the police investigate criminally Minister Gordhan and Ivan Pillay. But even if it were true that they have done what she alleges them to have done, and that's not determined, nobody suggests that what they have done is criminal, that there's a criminal matter to investigate. So she is asking our police to use our tax monies in a crime-ravaged country to go and investigate a matter that's not even criminal. So I think in these circumstances, absolutely, there is every reason to think that we should await a court's final determination as to the soundness of the remedial action.
So the chances that her actions may be unlawful or irrational is something that has to be considered?
I would absolutely, yes.
Okay. So we're going to leave it. Thanks very much.
Thanks
for coming through. Nicole Fritz, who is Executive Director of Freedom Under Law.